Reaction pouring in this morning after 5 former World Junior hockey players were found not guilty of sexual assault.
For years, public perception was shaped by a one-sided narrative from a civil lawsuit that went unchallenged, in large part because Hockey Canada settled the claim without first informing or consulting the players.
Cal Foote, Dillon Dubé, Alex Formenton, Carter Hart, and Michael McLeod all found not guilty of sexual assault charges for an alleged incident that happened in 2018. Michael McLeod was also found not guilty for the charge of being party to the offense. For more on the verdicts, we are joined in studio by lawyer Jillian Nachu. Jillian focuses on sexual assault cases in civil court. Jillian, good to have you here today.
Good morning.
Let's talk about language here because Justice Kelsey said she did not find the accuser's evidence to be, quote, credible or reliable. Were you surprised by the verdicts?
Candidly, I wasn't surprised by the verdict or the acquittals. I'm never surprised by an acquittal in a criminal sexual assault case. I was surprised by some of her reasoning. She really does seem to have accepted defense counsel's arguments in full, and I am among the many who are still poring over her 90-page decision, but there were some things I found surprising, yes.
Let's talk about specifics then. Justice Kelsey spent hours and hours unpacking evidence the court heard during the trial. Let's talk about the language she used. Walk us through that a little bit and your perception of that.
She seems to have accepted the defense's theory, was really what it boils down to. And I think that transcends her decision with complete respect to Justice Kelsey and her role as a judge. She does have a background as a criminal defense lawyer. She was in the criminal defense bar for many decades before she was appointed to the bench. And I do see that in her perspective on these issues and the language that trickles through.
In the days leading up to the verdicts, there were growing conversations over how this case could change how consent is viewed in Canada, in this country. So does this change anything?
I think it just cements the way we've been doing things for too long. I think it's further demonstration of how ill-equipped the criminal law is to understand the subjective experience of the less powerful person in the situation, typically women. I'm going to use gendered language because the evidence is overwhelming that sexual assault is committed against women by men. And so I think the criminal law is just very poorly equipped to understand not just the subjective experience of women, but also the impact of trauma on memory and the way in which somebody will act and cope in the moment when their sort of amygdala is triggered and their survival instincts kick in.
So what needs to change then? Where do we start?
There's probably a lot of things that could change in terms of the judiciary's understanding of the impact of trauma on memory. Fundamentally, there is a very high standard for conviction in criminal cases, and there are very good constitutional reasons for that. We don't want to be sending innocent people to jail. And so I think some of what has to be accepted is that the system functions as it was built, and that we have to stop being so singularly focused on the criminal system to met out quote-unquote justice, and that perhaps we as a society need to build alternative pathways to accountability.
So not necessarily, this is the way the system was built, and if I ask you a question about, did the prosecution do their job as well as they could have?
Yes.
Is that tough to answer?
It's tough to answer without having been in the courtroom for 9-10 weeks. I think that the prosecution did do their job. You may recall that there was a sexual assault case against Jacob Holgard, who was convicted, in fact, a couple years ago. And the Crown in that case did call an expert to speak to the impact of trauma on memory and survival skills. And that case was appealed, that verdict was appealed, and the Court of Appeal later said that that was improper oath helping, essentially, that you shouldn't have to call an expert because judges should know about these things and they can instruct juries accordingly. But I think that lawyers who practice on the ground really question how it is that judges are supposed to know about things when they've never been so taught, and when the rules of evidence are so at odds with what neuroscience tells us about our brains.
The Crown has 30 days to appeal.
Yes.
Do you expect that's going to happen?
No. I haven't, again, read every page of her 90-page decision, but I don't anticipate an appeal.
We appreciate your time, Gillian. Thanks for being here today.
I'm happy to be here.
If you like that video, make sure to subscribe to the Your Morning YouTube feed, where you can find all kinds of new content posted every weekday morning.